Hello students, in this lecture I am going to discuss with you part number 2 on the classification of the contract. Part number 1 have already been discussed by us in lecture number 4. Now let us start the video. In this video we are going to classify the contract on the basis of the enforceability, validity or legality of the contract. So, on the basis of the legality of the contract, it may be classified into four parts. It may be the valid contract, which is enforceable by law. It may be the void contract, which is not enforceable by law. It may be voidable contract when it can be declared void at the option of the aggrieved party, or it may be unenforceable contract when it is not enforceable by law even though the contract is valid, but due to certain technical defects it cannot be enforceable in the court of law. Now let us discuss all four categories of the contract one by one. First of all, what is the meaning of valid contract? An agreement which satisfied all the essential elements of enforceability. Okay. An agreement which satisfied all the essential elements of enforceability which are laid down under section 10 of this act, or which are laid down in any other special law governing that contract are called valid contract. So, in valid contract, the parties to the contract are bound by the terms of the contract. And in case any party to the valid contract tried to avoid their liability under the contract, then the other party can go to the court and can enforce the same against the other party through the court of law. So the valid contract is that contract which is enforceable by the court of law. So this is something about valid contract. And what is the meaning of void contract? Void contract was valid when it was made, but due to subsequent impossibility or due to the subsequent changing of circumstances, it becomes void. So what is the meaning of void contract? A void contract is one which was a valid contract when it was made, but subsequently it becomes void due to change of circumstances or because of subsequent impossibility or subsequent illegality. Okay, means to say when the contract was made it was possible to perform, but subsequently it becomes impossible to perform, becomes the void contract. A contract which was legal when it was made, so it was valid contract, but subsequently due to the change of law it becomes illegal, so after it becomes the void contract. A void contract is defined in section 2 clause J of the act as a contract which ceased to be enforceable by law, becomes void when it ceases to be enforceable. Now let us take an example of void contract. A agrees to sell his horse to B for a sum of rupees 60,000. Okay, but the horse died in an accident. In this case, it becomes impossible to perform the contract due to the destruction of the subject of the contract. And what was the subject of the contract? It was the horse. And as the horse had been died after making the contract but before the performance, so a valid contract converts into a void contract due to subsequent impossibility of performance. Okay, it is very important to see that when a contract becomes void, it is not a fault of any person, but the party who had received any benefit under the contract is liable to restore it or to compensate it to the other party from whom the advantage had been received. So this is something about void contract. Now let us discuss what is the meaning of voidable contract. When the consent of one contracting party had been procured by unfair means, then the contract becomes voidable contract. So what is written in the notes? When the consent of the party to a contract has been procured by unfair means, that means by coercion, undue influence, fraud, misrepresentation, or by mistake, then the contract is voidable contract. In this type of voidable contract, the aggrieved party whose consent had been taken by unfair means has two options. Either that party can affirm the contract as such, or to get a declaration from the court of law for setting it aside. If the aggrieved party chooses the first option, that means to say the party affirms the contract as such, then the aggrieved party has performed the contract as per the terms of the contract. Because the voidable contract remains valid unless and until it is set aside by the court of law. Okay, but if the aggrieved party chooses the second option, then he can set it aside from the court of law after proving in the court that his consent was obtained by unfair means. But if the court gives the declaration that the consent of the aggrieved party has been obtained by unfair means, then the aggrieved party is liable to return any benefit which he had received from the other party to the contract under the contract. The aggrieved party is also entitled to get the compensation. Okay, the aggrieved party has the remedy to get the compensation for any damage or loss which he had to incur due to this type of contract. And now the fourth category of contract is unenforceable contract. A contract which is otherwise valid, a contract which fulfill all the essential element of a valid contract but cannot be enforceable by law due to some technical defect is called unenforceable contract. So what is the meaning of unenforceable contract? An unenforceable contract is one which is otherwise valid but cannot be enforced by law due to some technical defect, and that such a technical defect may be understamping. The stamp is not properly stamped on that particular document. It may be the undervaluation of the stamp, or if there is absence of writing to the document which is required by the law to be in writing, or if there is no attestation or registration, if the attestation or registration is required by law to be made. So such contracts are not enforceable till the defect is corrected. The parties to this type of contract cannot sue each other. It cannot be proved in the court of law. It is very important. It cannot be proved in the court of law. You cannot establish your right on the basis of unenforceable contract in the court. So I want to repeat it here. An unenforceable contract is one which is otherwise valid but cannot be enforced by law due to some technical defect such as understamping, absence of writing, attestation or registration. Such contracts are not enforceable till the defect is corrected. The parties to this type of contract cannot sue each other. It cannot be proved in the court of law. We have already learned section number 10, and in section number 10 there is a proviso which provides that if an agreement fulfill all the required conditions which are mentioned in para number 1 of section number 10, but if there is a further requirement of stamping, writing, attestation or registration under any particular law, then that requirement is to be complied with. If that requirement are not complied with, even if all the other essential elements of the contract has been complied with, even then the contract remains to be unenforceable in the court of law. It cannot be proved in the court of law. So this is something about this lecture. Thank you very much.